Is the president of the United States as powerful as he thinks he is? It sounds like a rhetorical question, doesn't it?
It really does.
But looking at this stack of research you've pulled together, it's actually the kind of the big question hanging over the entire American political experiment.
It is. It's the question that keeps constitutional scholars up at night.
Welcome back to the deep dive. Today, we are getting into the weeds of what I think is the ultimate tug of war in politics. We're looking at the tension between the executive branch, the president, the commander-in-chief, and the judicial branch, specifically the Supreme Court. It's that classic battle of checks and balances where the president tries to flex a little muscle, maybe, expand the job description a bit.
And the Supreme Court has to step in and say, whoa, hold on a minute.
Exactly.
And what makes this deep dive so interesting to me is that we aren't talking about abstract theories in, a textbook. We have a stack of materials here, case studies, legal history, political science slides, that track this dynamic through real, messy history. We're going from the paranoia of the Nixon era through the scandals of the 90s and right into the post-9/11 war on terror.
So our mission today is to figure out the rules of the game. We want to uncover the specific mechanisms the court uses to check presidential power. We want to find those moments where presidents realized, usually the hard way, that they weren't, the kings of America.
And if we connect this to the bigger picture, it's about the durability of the law. When the most powerful person on earth says jump, does the Constitution say how high, or does it say sit down?
Okay, let's unpack this. If we're talking about presidents hitting a brick wall, we have to start with the smoking gun.
We do.
We're going back to the 1970s, Richard Nixon, Watergate. The source material highlights United States v. Richard Nixon from 1974.
Right, and to really get the stakes here, we have to set the scene properly. It's after the 1972 election. You have the break-in at the Democratic National Committee headquarters, 5 guys arrested.
And over the next 2 years, it slowly comes out that this wasn't just some random burglary.
No, it was part of a massive political espionage campaign.
And the twist, which honestly feels like bad movie writing, but it's real, is that Nixon was tape recording his own conversations in the Oval Office.
Which is a gift to prosecutors, theoretically.
Theoretically. But here's where the legal battle starts. When the special prosecutor demanded those tapes to see if Nixon was involved in the cover-up, Nixon he refused. He didn't say, I'm guilty, obviously. He said, you can't have them because I'm the president.
This is where we have to define executive privilege. Nixon wasn't just being stubborn. He was making a real constitutional argument. He argued that for a president to do their job, they need complete confidentiality.
Which, playing devil's advocate here, kind of makes sense, doesn't it? If I'm the president and I'm asking my advisors for advice on a crisis, I need them to be honest.
Of course.
If they think everything they say is going to be on the nightly news or in a court record next week, they're just going to tell me what I want to hear.
That was exactly Nixon's argument. He said that if you strip away that secrecy, you weaken the presidency itself. He claimed this privilege was absolute.
He thought he was the sole judge.
The sole judge of what could be released.
So it goes to the Supreme Court, the president versus the United States. And looking at the data here, Nixon probably felt pretty good about his odds. He'd appointed 4 of the sitting justices.
He did. But the ruling, it was a shocker. It was an 8-0 decision against him.
Wait, 8-0? There are 9 justices.
Right. One justice, William Rehnquist, recused himself.
Yeah.
Basically sat it out because he had worked in the Nixon administration previously.
Yeah.
But the other 8, unanimous.
So even the guys Nixon hired said he was wrong.
Yes. They ruled that while executive privilege does exist, specifically for things like military secrets or, diplomatic discussions, it is not a get-out-of-jail-free card.
So it can't be used to hide evidence in a criminal investigation.
Exactly. You can't use national security as a shield to cover up a crime.
Precisely.
On July 24, 1974, the court ordered him to hand over the tapes.
And looking at the timeline in the notes, 16 days later, Nixon resigns.
Because the tapes contained the smoking gun proof, he tried to stop the FBI investigation. But the key insight here isn't just that Nixon lost. It's who he lost to.
Right.
The fact that Justices Berger, Blackmun, and Powell, his own appointees, voted against him is so significant.
It really drives home the idea of judicial independence. I saw a phrase in one of the articles that called them presidential poodles, or rather that they aren't presidential poodles.
Right. Once they put on that black robe and get lifetime tenure, their loyalty shifts from the man who hired them to the Constitution itself.
Okay, so that's criminal law. The president isn't a crook. But let's fast forward a couple decades. We move from official secrets to something a lot more, well, tabloid.
A lot more.
Uh,
We're talking about Bill Clinton in the 90s.
William Jefferson Clinton v. Paula Corbin Jones, 1997.
And this shifts the conversation from official executive privilege to unofficial conduct.
Right. So Paula Jones alleged she was sexually harassed by Clinton back in 1991. The key detail here is that he was the governor of Arkansas at the time. This wasn't about his presidency.
No, it was about something that happened before he even took the oath of office.
Correct. So Clinton's legal team couldn't use executive privilege because it wasn't an executive act.
Yeah.
So they argued for, what, temporary immunity?
Temporary immunity. Their argument was essentially, look, the guy is busy.
I mean, that's one way to put it.
Basically, yes. They argue that the president has a unique role in our system. It's a 247 job. They said if we allow private citizens to sue the president for civil damages while he's in office, it's going to be a massive distraction.
He'll be tied up in depositions instead of running the country.
That was the fear.
And, again, I find myself sympathetic to the president's argument here. I mean, thinking about the political climate today, if you could sue a sitting president for anything that happened in their past, wouldn't political enemies just flood the courts with lawsuits to paralyze the White House?
It's a very real concern. And the court, they acknowledged that. But ultimately, they didn't buy it. They ruled 9-0 against Clinton.
Another unanimous loss.
The court ruled there is no immunity for unofficial conduct or for actions committed before taking office. They essentially said that the president is not above the law that applies to every other citizen.
Okay, but there is a specific part of the ruling written by Justice John Paul Stevens that I find fascinating because of how wrong it turned out to be.
Oh, I know what you're talking about, the prediction quote.
Yeah.
Justice Stevens wrote that allowing this lawsuit to proceed was highly unlikely to occupy any substantial amount of the president's time.
Highly unlikely to occupy any substantial amount of time. That did not age well.
It's one of the greatest understatements in legal history. Because, as we know from the source material, this decision forced Clinton to sit for deposition.
He had to answer questions under oath.
Under oath. And during that questioning, the lawyers for Paula Jones asked him about a relationship with a White House intern named Monica Lewinsky.
And we all know where that led. He lied about it, which is perjury.
Which led directly to his impeachment in 1998. The source calls this a massive, unintended consequence.
Wow.
The Supreme Court thought they were just letting a civil suit go forward, a minor procedural thing. They didn't realize they were pulling a thread that would unravel the entire presidency.
And just like with Nixon, the source notes that Clinton's own appointees, Ruth Bader Ginsburg and Stephen Breyer, voted against him.
It reinforces that theme. When the law is clear, the justices tend to stick to the law, regardless of who appointed them.
So we've covered a criminal cover-up and a civil scandal, but now we need to shift gears to something that feels much heavier.
Much heavier.
We need to talk about the war on terror.
This is the third and arguably most complex bucket of presidential power: national security and war. Historically, this is where presidents feel they have the most authority, the commander-in-chief power.
Right. When the country is under attack, the president usually gets whatever he wants.
Usually. And we're looking at the George W. Bush administration following the 9/11 attacks. Specifically, the situation with detainees at Guantanamo Bay.
And looking at these case summaries, it seems like the Bush administration was trying to be very clever with geography.
They were trying to create a legal black hole. The administration argued that because Guantanamo Bay is in Cuba, at least from Cuba, it is technically not United States soil.
So their logic was, the Constitution applies in America, Guantanamo is not in America, therefore the Constitution doesn't apply there.
Exactly. They believed that foreign detainees held outside the U.S. had no right to habeas corpus.
Okay, let's pause and define that because it's a Latin term that gets thrown around a lot. Habeas corpus basically means you have the body, right?
Right. In legal terms, it's the right to challenge your detention. If the government locks you up, you have the right to go before a judge and say, hey, you have the wrong guy, or you have no evidence.
The government has to prove why they're holding you.
Yes. And Bush argued that these terror suspects didn't have that right because they weren't on U.S. soil.
So the Supreme Court had to decide if that little map trick worked. This brings us to the first big case, Rasul v. Bush in 2004.
And the court ruled 6-3 against the administration. They said, look, the U.S. has complete control and jurisdiction over that base in Cuba.
So it doesn't matter what the lease says.
It doesn't matter. For all intents and purposes, it's under American rule. So yes, U.S. courts do have jurisdiction.
There's a quote here from Justice Sandra Day O'Connor that really stands out.
I know the one.
She wrote, "We have long since made it clear that a state of war is not a blank check for the president."
That phrase, not a blank check, is the key takeaway. Just because we are at war doesn't mean the president can do whatever he wants without oversight.
But the administration didn't just give up, right? Reading through this timeline, it feels like a tennis match.
It really does. The court hits the ball back, and the president adjusts his stance.
So what was the adjustment?
They pivoted. After Rasul, the administration said, okay, fine, they can have a hearing. But we aren't going to use regular civilian courts with juries, and we aren't going to use standard military courts-martial.
So they invented something new.
They created military commissions. These were tribunals where the rules were, say, flexible. Hearsay was allowed. Defendants couldn't always see the evidence against them. It was a system designed to get convictions.
And that leads us to the second case, Hamdan v. Rumsfeld in 2006.
Another loss for the president. This time a 5-3 decision. Chief Justice Roberts had to recuse himself because he dealt with the case on a lower court.
So the court struck down these commissions. What was the reasoning this time? Was it about fairness?
Partly, but mostly it was about separation of powers. The court said, Mr. President, you can't just invent a new judicial system on a napkin. If you want to try people in a new way, you need Congress to pass a law authorizing it. The president can't be the lawmaker, the prosecutor, and the judge all at once.
So Bush goes to Congress. And since the Republicans controlled Congress at the time, they passed the Military Commissions Act of 2006, basically giving him the green light.
Which sets up the final showdown. Boumediene v. Bush in 2008. Now the president has Congress on his side. He has the law.
But the detainees sued again, arguing that the review process still wasn't a fair habeas corpus hearing.
And this one was a nail-biter. A 5-4 decision.
Wow, that's close.
Incredibly close. Justice Kennedy was the swing vote, and he sided with the detainees. The court ruled that even with Congress's blessing, the procedures were inadequate. They weren't giving detainees a real day in court.
Justice Kennedy had a powerful line here, too. He wrote, "The laws and Constitution are designed to survive and remain in force in extraordinary times."
It captures the essence of the court's role. It's easy to follow the Constitution when things are calm. The test is whether you follow it when things are extraordinary, when you're scared, when there's a war on.
Now, I want to look at how President Bush reacted to this. I mean, 3 strikes is a lot. He's the commander-in-chief during a war, and the court keeps telling him no.
This is crucial. The source quotes Bush's response to one of these rulings. He said, "We'll abide by the court's position, but that doesn't mean I have to agree with it."
We'll abide, but I don't have to agree.
It perfectly illustrates the tension. There was disagreement, strong, vocal disagreement, but ultimately there was compliance. He didn't order the military to ignore the judges.
So we've seen the court slam the brakes on Nixon, Clinton, and Bush. But to be fair, does the court always say no? Or are we just cherry-picking the dramatic moments?
That's a fair check. And the answer is no, they don't always say no. The pendulum swings. If we look at the historical context provided in the slides, there are cases where the court gave the president a lot of room.
Like what?
Well, take Myers v. United States in 1926. The court ruled that the president has the power to fire executive officials without needing Congress's permission. That was a big win for executive power. Or Goldwater v. Carter in 1979, where the court effectively allowed President Carter to terminate a treaty with Taiwan unilaterally.
But when they do push back, it's usually because the president has overreached significantly. We can't talk about overreach without mentioning the steel mills. Youngstown Sheet and Tube Company, Sawyer, 1952.
The classic. This is during the Korean War. A strike was looming at the steel mills. President Truman said, "We need steel for tanks and guns." So he just take it. He issued an order seizing the mills.
He took over private industry.
And the court said absolutely not. But there's a funny detail in the source about this that I love. Truman was furious.
Yeah.
But not just at the ruling at who made it.
Right, Justice Tom Clark. Truman had appointed him.
He had.
Truman later called appointing Clark his biggest mistake, calling him a damn fool from Texas.
It's a harsh assessment, but it underscores that unpredictability we talked about earlier. Presidents always think they're appointing allies, but they were often appointing their future hurdles.
Speaking of the bench, let's look at the current court composition, as listed in our source material. Because people always talk about the politics of the court.
It does matter. The source breaks it down by who appointed whom. At the time of this source's compilation, we're looking at a court with a clear conservative majority, 6 Republican appointments versus 3 Democrat appointments.
And looking at that, a cynic might say, well, of course, a conservative court will block a liberal president and vice versa. But looking at our examples today,
It doesn't quite hold up, does it?
no. Nixon was a Republican blocked by his own Republican appointees. Clinton was a Democrat blocked by his Democrat appointees.
And even in the Bush cases, Rasul, Hamdan, you saw diverse coalitions. It wasn't always a strict party line vote. The political thicket, as the legal scholars call it, is messy.
So let's zoom out. What does this all mean? If we step back from the specific cases, what is the Supreme Court actually doing here?
I think the best way to describe it, based on these sources, is that the Supreme Court acts as a constitutional referee.
A referee.
Yes. Think about the incentive structure. The president, whether it's Nixon, Clinton, Bush, or anyone else, is always going to push for more power. It's the nature of the office. They want to solve problems. They want to win wars. They want to protect their staff. They're always going to try to move the line.
And the court's job is to blow the whistle and say, you stepped out of bounds.
Exactly. They establish that the executive branch is not absolute. No one is above the law, not even the guy with the nuclear codes.
There is a massive structural irony here, though, isn't there?
You mean how the referee gets the job?
Yeah. The president appoints the very people who might later tell him no. It's like a football coach hiring the referees for the Super Bowl.
It is a design feature, not a bug, but it's certainly ironic. You appoint them hoping they share your worldview, hoping they'll back you up. But because of lifetime tenure, because you can't fire them once they're in, they don't have to follow your orders.
It forces a separation. It turns a subordinate into an equal.
It does. But I want to leave you with a provocative thought, something that lingers behind all these cases, from the tapes to the detainees.
Go for it.
The entire system relies on the president agreeing to listen. Think about it. When the Supreme Court told Nixon to hand over the tapes, Nixon had the Secret Service. He had the military, the court. It has a marshal and some security guards.
He could have just burned the tapes.
He could have. Or when they told Bush his military tribunals were illegal, he was the commander-in-chief during a war, he could have said, I'm protecting the country, get out of my way.
But they didn't. Bush said, I'll abide. Nixon resigned.
The system works because of that voluntary compliance. But the unwritten, scary question behind all checks and balances is, what happens if a president decides the political thicket is too thick and chooses not to abide? What happens if they just look at the Supreme Court and say, make me?
That is a terrifying and fascinating thought to end on. The system holds because the players agree to the rules.
Precisely. It's a fragile strength.
Well, on that night, we're going to wrap up this deep dive. We've gone from the Watergate break-in to the cliffs of Guantanamo, seen presidents humbled and the Constitution upheld. Thanks for listening, and we'll see you on the next deep dive.